In the modern digital age, privacy may seem non-existent, but believe it or not, there are laws that protect people's privacy on the internet. Hi, this is Professor Grabowski, and in this video lecture, I'm going to cover the issue of online privacy. Specifically, I'll discuss what information is private and what information is publicly available. First, let's start with the good news. There are some privacy protections online. In the United States, the law recognizes that everyone has, under certain circumstances, a right to simply be left alone. The law recognizes that there is certain information, certain actions, and certain places that are nobody else's business. While the law can vary by state, U.S. courts have generally recognized 4 different types of invasion of privacy. They are, first, public disclosure of private and embarrassing facts. Second, false light. Third, misappropriation. And fourth, intrusion. These laws apply to both the physical world and the online world. I'll briefly explain how they protect you on the internet. First, let's begin with public disclosure of private and embarrassing facts. The most common type of invasion of privacy that occurs online is probably public disclosure of private and embarrassing facts. This type of privacy breach occurs when someone shares information about someone else that is so private, so intimate, and so embarrassing that a reasonable person would be shocked that it was actually shared. In order to successfully make this claim, the information must actually be true, since that's what makes the revelation of it embarrassing. This violation usually involves the type of information that should raise some red flags prior to posting online. For example, providing graphic details about a person's private sex life, disclosing that a person has a health condition that they've not publicly revealed, or sharing detailed information about a person's grades without a legitimate or newsworthy reason would be examples of this type of invasion of privacy. On the other hand, it's likely not public disclosure of private and embarrassing facts if the information is already well known or if the information shared is just mildly embarrassing. For example, a revelation that someone ate insects or likes to read romance novels would not be considered an invasion of privacy. The primary defense to this kind of invasion of privacy claim is that it was newsworthy or in the public interest, and therefore sharing it was justified. If information is truly newsworthy or in the public's interest to know, it will not be considered a violation. Publishing information that is part of public records, such as arrest and court records, or a person's age and birthday, or the house a person owns, is perfectly legal. Also, if a person gives permission to someone to publish otherwise private information about them, they generally cannot later claim their privacy has been invaded. Finally, if a person posts information about themselves online, on a website or social media account, they likely cannot sue for invasion of privacy when someone else shares it. That's why doxing someone is usually not illegal. If you're merely sharing a screenshot of an old social media post someone made to embarrass them, you're not invading their privacy. It's not illegal. That said, there is a debate to be had over whether it's ethical to do that. In recent years, several victims of revenge porn have successfully sued using public disclosure of private and embarrassing facts laws. Revenge porn is when someone posts sexually explicit images or videos of a person on the internet without the consent of that person. So just because someone may text an image of themselves naked, that doesn't mean the receiving person can share that image with all their friends. If they do share that image, they could be sued for invasion of privacy. And they could also be arrested, since almost every state now has criminalized the act. The second common category of invasion of privacy claims is known as a false light, which is the publication of truthful words or images in such a way that it gives a false impression or portrays someone as something they're not. Not all states recognize this type of invasion of privacy because it's similar to a defamation claim in that it's based on a false impression. One example of false light would be posting a photo on Facebook or Instagram with an extremely misleading photo caption. For instance, a Chicago plastic surgeon was sued by a former patient after allegedly posting before and after pictures of her nose surgery on his website and labeling those pictures cocaine nose, even though that was not the cause of the patient's condition. A recent development that would likely qualify as false light is what's known as lookalike pornography, or deepfake porn, in which artificial intelligence technology is used to swap celebrities' faces into porn videos. The third common type of invasion of privacy you should know about is misappropriation. Misappropriation is also sometimes referred to as a violation of the victim's right of publicity. Fortunately, misappropriation is the easiest type of invasion of privacy to spot and avoid. You can get sued for misappropriation if you use another person's name, voice, image, or other likeness to help sell something without first obtaining that person's permission. The main trouble spot is usually advertising and commercial endorsements. If you want to use the name or photo of someone in an ad to help sell something, you must first get their permission. For example, after a dietary supplement garnered attention on the Oprah Winfrey Show, many websites popped up that made unproven health claims and used Oprah's endorsements for pills made from the supplement. In response to the misappropriation of their names, Oprah Winfrey and her medical guest expert, Dr. Oz, publicly denounced the websites, said they did not endorse the products, and filed a lawsuit. Be aware, it doesn't matter whether the misappropriated person is famous or not. Everyone has a right of publicity, which means they have the right to decide how their likeness is used when it comes to advertising and endorsements. For example, Facebook settled a class action lawsuit brought by its users after it used profile pictures and ads on the site based on users liking a particular brand's Facebook page. If you operate a website, you should be particularly careful in how you use other people's photos. In order to avoid lawsuits, the best practice is to obtain signed permission before producing any ad that includes pictures of identifiable people. If the person is a child and money is involved, you should also get permission from the parent or guardian. But note that this right only applies to advertising. If a journalist takes your photo for a story or mentions your name in a story, you can't sue the newspaper or TV station for violating your right to publicity. Similarly, if a stranger takes a photo while you're at the beach and you happen to be in it, you can't sue them unless that photo is used in advertising. The final common type of invasion of privacy is what's known as intrusion. Unlike other types of invasion of privacy, intrusion claims are not based on what is published, but rather on how the information was obtained in the first place. The law provides that there are certain private places that are off limits to others unless a person gives others permission to be there. In the real world, homes, bathrooms, and private offices are common examples of a private place where a person could be found to have invaded someone's privacy if they entered without permission or if they planned a secret listening device or camera to spy. For example, in 2021, an Adelphi University student was arrested for allegedly planning a hidden camera in a dormitory shower to record another student while she showered. In addition to being charged with a crime, this student was expelled from the university. And this Peeping Tom student's name appeared in many news stories because, as I mentioned earlier, arrests are considered a public record. Victims' names sometimes also end up in police reports and court documents. Under a 1975 Supreme Court ruling, victims' names are legally considered part of the public record and can be published. However, journalists typically do not publish victims' names as a matter of ethics. If victims had to worry about having their name published in the media, they may be less likely to come forward and report crimes. Be aware that people do not have an expectation of privacy when they are in a public place. So if someone records you on the street, in the subway, in a park, at a stadium, or a public place like that, it's not illegal. People generally have the right to observe, photograph, or shoot video and post online anything that happens in public spaces. Some places may fall in a gray area, and it may be left to a court to decide how public or private the space is. The key question in such cases is, does the person suing for intrusion have a reasonable expectation of privacy in this particular location? If the answer is no, there can be no successful claim. So to review, those are the 4 types of privacy protections that are commonly recognized by states. Keep in mind that the aforementioned laws are general privacy laws that exist throughout the United States. Some individual states have been more progressive in protecting their residents' privacy and have enacted additional laws. California, for example, has been a leader on privacy law. Its laws include banning employers and schools from asking for applicants' passwords. The Golden State also requires police to get a warrant for any online data. California also prohibits paparazzi from flying drones above private property to record any activity. And finally, California also gives children the right to erase social media posts. Most recently, the state's Consumer Privacy Act went into effect in 2020 and gives consumers the right to opt out of selling of their personal information. And it requires companies that collect such data to make individual users' information available to those users if they request it. Many more pieces of legislation aimed at expanding Californians' digital privacy rights are under consideration. But keep in mind that these laws only apply in California and only protect California residents. In addition to state laws, certain professions have additional privacy standards that must be followed by the people working in that profession. For example, doctors, nurses, and other healthcare professionals must abide by the Health Insurance Portability and Accountability Act, also known as HIPAA. HIPAA protects patient privacy by limiting what information medical professionals can share about patients with their family, friends, and the public. HIPAA covers electronic health records and electronic communications as well. In addition, school officials and teachers must follow FERPA, which stands for the Family Educational Rights and Privacy Act. This federal law protects students' privacy. Under this law, professors, for example, cannot discuss a student's grades or class performance with the student's parents unless the student gives the professor permission to do so, even if the parents pay the student's tuition. So there are actually many laws in America that protect privacy. But here's the bad news. There's also a ton of information that many people consider personal that is not considered private in the eyes of the law, and it's available for the public to know. A big reason for that is that privacy laws in the United States have not been updated in about 4 decades. And of course, the world has changed a lot since then. Back when our laws were last updated in 1986, almost no one had a cell phone, and the only drones flying above were bees. Mark Zuckerberg, the founder of Facebook, was only 2 years old, and the only social networking he did was at preschool. Back then, if you did something embarrassing, people eventually forgot about it, or if worse came to worse, you could change your name and move away. No one in your new community would know who you are because you'd have no online history. In a digital world, however, every move and action can be tracked, collected, archived, and analyzed. Unlike people, the internet never forgets. So now, that information lives online forever, and people can permanently suffer because of a stupid mistake they made as a teenager. Unfortunately, our privacy laws have not been updated to keep pace with technological changes. America's privacy laws are grossly outdated. Let's take a closer look at some existing loopholes in U.S. privacy law and how they undermine our privacy online. Here's one example. In order to get information about a person in the physical world, police typically must obtain a warrant. That means before police can search your house or computer, or even find out which library books you borrowed, police must prove to a judge that they have a probable cause or a reasonable basis that evidence of a crime will be discovered. However, the standards are much more lax for the internet. Under current law, law enforcement agencies are not required to obtain warrants to access online materials if they're older than 6 months old. And draft emails, web browsing history, and files stored in the cloud are available without a warrant regardless of how old they are. Americans' privacy protections have gotten even worse in recent years. As a result of September 11th and fear of another terrorist attack, Congress passed a law known as the Patriot Act that gave law enforcement incredible surveillance powers to closely monitor citizens' internet activity. This law gave law enforcement so much power to snoop online that it arguably undermines our civil liberties. And when law enforcement demands big tech companies such as Google and Facebook hand over data about their users, those companies rarely put up a fight. Although companies like Apple advertise how they protect users' privacy, the reality is they comply with the government's information requests 90% of the time. In fact, it was recently revealed that Google is now sharing keyword search analytics with law enforcement. Police may ask Google who is searching for certain words or certain locations on maps in order to find suspects in crimes. And Google complies with these requests, which are essentially phishing expeditions. Even the personal printer you use at home for your computer may snitch on you. Printers manufactured in America contain what's known as a machine identification code. It's basically a series of yellow dots or a watermark that's invisible to the naked eye, but that the FBI can use to trace the origin of a document, such as an anonymous bomb threat or a harassing letter to a congressman. The government isn't the only one taking advantage of America's outdated privacy laws. Private companies are also exploiting these loopholes. Cell phone carriers, internet service providers, websites, and apps can mine all kinds of personal information about their users and often sell it to the highest bidder. Expert James Janney explains this practice, which is known as data mining.
It's a lot easier than you would think. Nowadays, people give out their information willingly and without realizing that this data can be extracted and sold. Begin with public information, things that you can find on someone's social media pages.
There was nothing to hack. People were going to provide their own pictures, their own information.
The pages that they like, the places that they've visited, relationship statuses, hobbies, friends lists. Look at property records, land registries, court records, birth certificates, voter registration information, bankruptcy records. And with all this data that we've gathered, we can start to identify patterns in how you behave and what your overall personality is like. By looking at just a few of your likes on Facebook, we can accurately predict what your political affiliations are. By looking at just your purchase history, we can guess how old you are, whether you're looking to lose weight, and whether you're a parent. By looking at your frequent locations, we can determine where you live, where you work, what restaurants you like to visit the most, whose houses you visit the most. By looking at your credit score, we can assess what level of income you're at and how much debt you're in. By looking at your contact list, we can determine who your closest friends are, how often you call them, and whether or not you've fallen out with them based on the frequency of those calls. By looking at your internet history, we can determine any health-related concerns you have, your religious affiliations, what your interests are, whether you're planning to go abroad or not, what you're thinking about purchasing. All of these predictions allow us to create a profile for each individual on our data sets. A profile that can detail exactly who you are as a person, how you think, and how likely you are to behave. That is our product, a well-wrapped package filled with an individual's behavioral patterns. And once we've packaged all this data into profiles, audiences, lists, it's time to start selling.
All of these aforementioned practices raise serious privacy issues that have not been fully explored and debated. But that's not all. Your university, or the company you work for, is likely also exploiting these privacy loopholes. Under the current laws, schools and employers can Google stalk applicants without their knowledge. A person can be rejected for a job or from a college because of a scandalous photo a friend posted of him on Facebook years ago, and he'll never know the reason for that rejection. Some schools and employers have gone so far as requiring applicants to reveal social media passwords, a practice that is currently prohibited in only about half of the states. Once hired for a job or enrolled in a university, your boss or school administrators may also monitor all of your internet activity. In fact, one survey found that 1 out of every 3 IT employees admit to taking a peek at coworkers' data, including private files, paychecks, and personal emails. Courts have ruled that employees and students have no reasonable expectation of privacy when using an organization's computer. Can these privacy loopholes be fixed? Yes, it doesn't have to be this way. The European Union, for example, recognizes a right to be forgotten. Under EU law, individuals may request that search engines such as Google remove search results for their name under certain conditions. Europe also has a number of other privacy protections, including laws that limit data mining. But in the United States, lawmakers have not made much progress on these issues. For example, Congress rejected a proposed federal law that would have prevented employers from demanding social media passwords. Meanwhile, the U.S. Supreme Court has been reluctant to address these issues and to make broad declarations on how existing privacy laws should be interpreted in the Internet age. For example, can the police search your email messages without a search warrant? Can Facebook track what you do on their site and which sites you visit after you leave their site? Congress and the courts have so far declined to address many of these issues on a national level. On the other hand, the situation could be worse. Americans could have even less privacy protections than they currently do. For example, in China, the government uses facial recognition and big data to control and monitor its citizens. In 2020, China fully rolled out its controversial social credit score system to closely monitor citizens' everyday behavior and punish or reward them according to certain standards of appropriate conduct. Under this intrusive surveillance system, both financial behaviors like frivolous spending and bad behaviors like lighting up in smoke-free zones can result in penalties, including loss of employment, loss of educational opportunities, and loss of travel privileges. Those with high scores get perks, such as discounts on utility bills and faster application processes to travel abroad. Some worry that a similar system may eventually be adopted in America, if not by the government, then by the private sector. Currently, several big corporations, along with Amazon and banks, are working behind the scenes to create what would essentially be a system that would assign Americans a social credit score. So, in addition to looking at your credit history, this system will also look at what you buy, which websites you visit, which movies you watch on Netflix, what you post on social media, and more. That information will then be sold to others who will make all kinds of decisions based off of it, such as whether you get approved for a mortgage, whether your application gets approved for a gym membership, or whether your profile gets approved for a dating app. It sounds like an episode of Black Mirror, but it could happen. So why do Americans tolerate this increasingly dystopian cyber world, where their every movement is tracked? Well, the complicated truth is that it benefits them in many ways. Instagram, TikTok, Google, and all the most popular sites and apps that you use are free to use because those companies make money by collecting and selling your data. You're the product. How many people would be willing to pay to use those sites? That's why we willingly check the box to agree to their terms of service. In doing so, we give websites, apps, and social media platforms permission to mine our data and sell it to others. Another benefit of sharing our personal information is that it provides convenience. Individuals can access all kinds of data at their fingertips that improves their own lives. For example, health researchers can use streams of data from patients' internet searches to reveal signals for possible drug side effects, or to identify other health concerns. That was the case in South Korea, where the government's heavy use of surveillance technology was cited as a reason for its successful containment of the outbreak and spread of the coronavirus disease COVID-19. By utilizing CCTV and tracking bank card and mobile phone usage, officials there were able to identify who to initially test for the virus. In addition, police have been able to solve many crimes and locate missing persons thanks to all the surveillance we have and the treasure trove of information available to law enforcement. These are just some of the countless examples of how data mining helps improve our lives. So, while the latest Facebook scandal may have everyone talking about privacy, we need to ask ourselves a difficult question. How many of us would be willing to give up such conveniences in exchange for more privacy? Many of us probably wouldn't even consider deleting our favorite apps or paying for them. Now, it doesn't make Google or Facebook's intrusions right, but it partially explains why we don't have stronger laws limiting the collection and use of our private data. That's something to think about and ponder. Well, That's online privacy in a nutshell. This has been Professor Grabowski, and thanks for watching.